After 9/11, the Bush administration, they kicked off a major security crackdown. You remember, it included sweeping up immigrants, mostly from Muslim countries, and they detained them for immigration violations. Now, the detainees claimed that they were subject to beatings, humiliating searches, solitary confinement. And they filed a class action lawsuit that has made its way all the way to the Supreme Court. High-level Bush administration officials, they're named in the suit. They include the former Attorney General John Ashcroft and former FBI Director Robert Mueller. Now, this case, it will determine whether they can be held liable for policies they helped to put in place. You know, Mark, I'm sure a lot of people right now are saying, wait a minute, federal officials, you guys can be, where does immunity start and stop for people in the federal government?
Well, as we discussed off camera, it really, Ashcroft, these people are being sued as policymakers, that they implemented a de facto policy of rounding up Muslim Americans in dragnet fashion immediately after the 9/11 attacks. So the question is whether that was a reason, first of all, whether that such a policy existed, and I think it's not really disputed that it did. The question is whether that was a reasonable reaction in the aftermath of the terror attacks when, you know, nobody really knew what was going on. It was a fog of war type situation.
Let's say it's reasonable. Do they have to also be responsible for what would be foreseeable, that it wouldn't just be detaining, but also some of the things that I mentioned that happened to those detainees, if proven true?
Well, I don't think that would be part of the immunity equation. This is a question of whether they can be subjected to the suit. If they can be subjected to the suit, then that would be a question of fact for a jury to decide whether this was reasonably foreseeable to them, and it would go into the damages. But the big thing here, as we talked about off air, is that Sotomayor and Kagan have already stepped off the case. They've recused themselves. Sotomayor because she may have been involved in proceedings below in the Second Circuit, our Court of Appeals, and Kagan because she was involved as Solicitor General. So I just don't see enough votes not to overturn the Second Circuit's decision, and enough votes to hold these people subject to trial for it.
Give the implications beyond this, and he's right. You do the math, there's only 6 justices left. It doesn't seem that this goes forward. But beyond that, I know I was, and people don't follow this as much, Jimmy, that federal officials, for a policy, right? This isn't war crimes or whatever. This is a policy put in place that you could be held liable for this now, obviously, 8 years later or 7 years later. Right?
Well, in Judge Raggi's...
I'm sorry, many more years later.
It started a long time ago.
Yeah.
Right.
So. Yeah.
In Judge Raggi's dissent in the Second Circuit, what she said was, you're right, they should have immunity from reasonable, even if mistaken policies, especially during a time of war and a time that utmost security measures needed to be taken. What troubles me, though, and I don't know, Mark, how this plays out, but it's not just a suit about implementing a policy, because I would tend to agree that the implications are not good if you can sue the President and the Attorney General for reasonable, even if mistaken policies. But if the suit is about you implemented a policy and then you knew and condoned the beatings and that, well, that I think is where the line gets drawn.
Yeah.
Plus, this is very limited. This is Bivens action. Basically, what you're saying is that there was a policy that they directed to use any reason to pick these people up. So basically, they're depriving people of their constitutional rights. And if you, very rarely will you see a lawsuit where the allegation is that an elected official or an appointed official is intentionally depriving somebody of their constitutional rights.
The Japanese internment from so many years ago is very similar. Now, I don't know if there were allegations as well of beatings and that kind of mistreatment, but you know, there's a big difference from implementing a policy and implementing a policy that also includes torture.
Well, also,
but
go ahead.
If you know that that policy is depriving people of their constitutional rights or violating international law, then you should be held liable. There should be no immunity. And even as former prosecutors, okay, as soon as we step outside of our role as prosecutors and we direct law enforcement to take action, we lose our immunity.
We'll keep this conversation going off camera.
Quick rhetorical flourish to my hockey season friends.
Yes.
Let's go Islanders.
And I will second from Mark. First time tonight. All right, coming up next, everybody. Bridgegate trial continues, and there are more and serious allegations against Chris Christie coming from some old so-called friends. We'll explain, plus new developments in the teacher sex abuse scandal in Chappaqua.